In this case, a victim and a co-conspirator were both shot.
So 2 people got shot in this whole ordeal. Motion for bond reduction denied. Bond will continue.
Assistant Public Defender Deputy Luba on behalf of Mr. Harvey. Mr. Harvey, could you tell the court your name, please?
You can say it.
No, you need to say your name, sir.
Sir, what is your name? Harvey. Your full name? Edward Harvey. Thank you. What are we doing?
Your Honor, I'd like to set this matter for preliminary examination, please.
Yes. So discovery is complete.
It is not, Your Honor. We're still waiting on receiving some body camera. Harvey's indicated to me that he would not like to waive any time frames and would like to set this matter for.
All right, but he understands also that if that does not appear, it's not going to be the basis for an adjournment.
He does understand that I did review those, Mr. Harvey.
We'll have their witnesses available on the 28th.
Can you reach out to the sheriff's department about the body camera? I heard that, but I think I need to do a little bit more discussions.
Preliminary examination will be set April 28th, 2026, 9 a.m. That's before me.
Thank you, Your Honor.
As to bond.
It's mentioned that the party has contacted a number that the victim is using 16 times, and how we know it's the number for the victim is she's referred to as his wife. He loves her, begging for her forgiveness. So at this point, I'm going to be asking for his calls and texts to be revoked. He talks about what might happen with the case, if they come to court, if they don't come to court. So at this point, I'm ask for his calls and texts to be revoked.
That's any response.
No, this is my first time hearing about this.
It's not too hard. Well, we'll get that to him. And at this point, I'm going to revoke the defendant's phone and texting privileges from the Washington County Jail.
Your Honor, Marcia Crater on behalf of Mr. Thompson, who's approaching.
Your name?
Davon Thompson.
Thank you.
Your Honor, we have 2 requests today. The first request is we'd like to proceed to preliminary exam. I believe discovery is complete. We have a sort of a special thing in mind that.
That's correct, Your Honor. The defendant's co-defendant, Boston Henning, is already set for preliminary examination on a special setting before Judge Freshour. And I would request that.
Okay. What date is that?
It's April the 29th at 1 p.m. at the 1484 District Courthouse.
Mm-hmm.
Yes. That's the co-defendant to this case?
That's correct.
Freshour, know it's coming?
I believe so. I was emailing with Ms. Ostrowski yesterday about this.
That date came about with the meeting that we had with Judge Freshour.
And I'm presuming then the people would have their witnesses available.
We'll do our best, Your Honor.
All right. Preliminary examination, April 29th, 2026. What, did at 9?
1 p.m., Your Honor.
1 p.m.
The second request comes from my client. He would like me to address bond briefly.
Go ahead.
Okay. My client stands before you, a young man who was 17 when this incident allegedly occurred. I believe his criminal history at the juvenile is pretty, I think he's got a CCW, if I'm not mistaken. But after that, there's nothing else. He does have family in the area. He's resided here his whole life. He explains to me that he'd be able to currently reside with his grandmother in Ypsilanti, and that he is needed to help with child care of his younger siblings. And so he's asking that the court allow him 10%. If the court does, we'll be asking for a PR bond in this matter. He'd be willing to do a house arrest on tether. That's our request today.
Your Honor, the defendant was involved in the planning and execution of an armed robbery where the item to be stolen was a firearm or firearms. The defendant has 2 firearm-related charges, CCW and reckless use of a firearm while a juvenile in 2025 and 2024, respectively. In this case, a victim and a co-conspirator were both shot. So I do believe the cash bond as that is appropriate.
So 2 people got shot in this whole ordeal. Motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
This bond ruling shows exactly how Judge Simpson is weighing personal mitigation against public safety concerns. The defense gives the court several reasons to consider release. Thompson was only 17 when the alleged incident occurred, has family ties, could live with his grandmother, and is willing to accept house arrest with a tether. Those are relevant because they give the judge potential tools to manage risk outside custody. But the prosecution answers with allegations that go directly to dangerousness, participation in the planning and execution of an armed robbery, prior firearm-related charges, and, most importantly, 2 people being shot during this incident. Notice how Judge Simpson reduces the dispute to that central fact. 2 people were shot. At this stage, the defense is not trying the underlying case. It is asking whether conditions of release can sufficiently address the court's concerns. The judge clearly decides that the alleged violence outweighs the proposed safeguards. Do you think house arrest and electronic monitoring were enough here, or did the shooting allegations make this request almost impossible to win? The defense presented mitigation, but the prosecution gave the judge a concrete reason to leave the existing bond untouched.
Marshal Page, on behalf of Mr. Wright, who's approaching. Bless you. Bless you again.
All right. Your name, sir?
George Willis Wright.
Thank you.
Your Honor, we'd be requesting a preliminary exam in this matter.
You have all discovery.
Yes, I do, Your Honor.
If other witnesses.
Bless you. Bless you again.
All right. Your name, sir?
George Willis Wright.
Thank you.
Your Honor, we'd be requesting a preliminary exam in this matter.
You have all discovery.
Yes, I do, Your Honor.
If other witnesses available the 28th. Preliminary examination person at the 28th, 2026, 9 a.m. before me.
Your Honor, my client is asking me to make a request for a PR bond, if I may, briefly.
Briefly.
Your Honor, my client stands before you. His last convict, I believe, for any crime was in 2024. Further, most notably, is my client has some health issues that require some surgery. The first one is some eye issues that require surgery at the Kellogg Eye Center, which he tells me he has surgery scheduled for April 20th. Is that correct?
Yes.
Okay. And that he also needs to follow up with a surgery in his abdomen that requires follow-up. He has been able to secure housing at Miller Manor. So he has no family there in the area to help him. Therefore, he needs to be out and about. Specifically, he needs to be able to get to his bank account for bond. What I'm being told by my client is, if the court is unwilling to reduce the bond, is that his phone privileges have been prohibited. I don't know if that's true or not, but because I haven't been able to research that through the jail, but he's asking to have phone privileges. So if the court is unwilling to give him a PR bond, then the court would be, he can then make arrangements with a bail bondsman.
Your Honor, at this time, the people are going to be objecting. This is the case was strangled by the defendant to the point of unconsciousness and walked to share the defendant for pleading guilty. He has a very lengthy history of domestic violence, including a DV conviction in 2010, 2 FAs from 2015, a DV conviction in 2019, and ongoing aggravated DV complaint for the 2023 domestic violence conviction, along with the dismissed DV for 2025. So at this point, I'm objecting. As to the phone privileges, I don't recall that being revoked. I don't believe that was the trust at arraignment. So
I don't see that. I ordered it. So I don't.
Right. My client says it's from a previous incident case that it was convicted, but if it is, then I guess a stipulated order from the court.
I'm not stipulating any. I don't know why they're revoked. It may be proper that they are revoked because I had contact the victim. So I'm not going to agree to anything regarding that. You can talk to the prosecutor about that.
All right.
With it, but I'm not agreeing. I want to make it clear. I'm not agreeing to restore anything.
Sure.
Motion for Brown reductions denied. Bond will continue.
Thank you, Your Honor.
This second bond argument reveals an important strategic problem. The defense is asking Judge Simpson to solve several issues at once, but the prosecution keeps bringing the discussion back to risk. Wright's attorney raises potentially significant practical concerns, scheduled eye surgery, abdominal follow-up care, housing, and difficulty accessing resources needed to arrange bond. But then the prosecution identifies what it describes as a lengthy domestic violence history, including multiple convictions spanning several years. That changes the court's risk analysis considerably. The phone issue is especially revealing. Defense counsel cannot confirm exactly why the privileges were restricted, while Judge Simpson refuses to restore anything without knowing the reason. That is a cautious procedural position. If a restriction could be connected to prohibited victim contact, removing it without verifying the underlying order could create an unnecessary safety problem. Did you notice how quickly the judge draws that boundary? He does not say the restriction must remain permanently. He says he will not change something when the record before him is unclear. Strategically, the stronger approach would require verified information: why the restriction exists, what medical arrangements are actually necessary, and what conditions could address the prosecution's concerns. Without that foundation, the requested bond reduction has little traction.
Excuse me, Kyle Burdell on behalf of Mr. Laster, who's approaching the podium.
Michael Gaddy on behalf of Mr. Laster in 23 FT 1486 and 1117.
Just attorney and a bond argument and a request.
How you doing, Justice?
Your name?
Robert Laster, Justice.
Doing?
Your Honor, on my case, at least, it's my understanding, based on what's in Mr. Gaddy's hand, we are both asking for adjournment at this time. I do have a bond request from the court. We'd like to hear it.
That's correct, Your Honor. I think it'd be prudent to keep all three together.
May 7th, 2026, 9 a.m. Esteban.
Your Honor, Mr. Laster.
May I approach, Judge?
Okay. Sorry, my approach. Oh, was it just a hand on the
Just
phone?
a hand in the
Oh, sure. Your Honor, as to the bond request, so Mr. Laster lives in Mississippi. He's currently basically couch crashing with a friend. And so his bond has already been modified from community corrections, or his community corrections already has instructions to allow him to test locally where he's at. But at this point, it's my understanding that he does not have permission to leave the state. So we just ask that he be allowed to return to his family. He has a 10-year-old daughter and an 8-year-old grandson back home in Mississippi that he needs to get home back to and take care of.
So first thing, though, is that he corrected the community corrections violations.
That is correct, Your Honor. He went and tested this morning. I spoke to him yesterday. I spoke to him yesterday. And he called yesterday before anybody said immediately after I informed him of the issue.
And I'll echo the same as Mr. Gaddy. He was very apologetic and Mr. Laster was very apologetic and eager to correct his misstep and his oversight.
Response from the people.
Your Simpson has gotten he did his initial test. I don't know if we have those results yet. It was just this morning. That would be something I might be interested in.
Before any agreement.
Yeah, just because there was that bond violation, not going to test for almost a week. Maybe a week, actually, now that I think about it, it was the night.
Motion for bond modification. All right, bond will continue as it's actually can't be the same.
Understood.
Thank you.
State your
7.
Thank you.
Across these hearings, Judge Simpson applies a consistent principle. A defendant's personal circumstances matter, but they do not automatically outweigh unresolved concerns about safety or compliance. Thompson offers youth, family support, housing, and electronic monitoring, yet the prosecution points to an alleged armed robbery in which 2 people were shot. Wright presents medical needs and housing concerns, but the prosecution emphasizes an extensive domestic violence history, while uncertainty surrounding his phone restrictions gives the judge another reason not to make an immediate change. The final bond request involving the defendant seeking permission to return to Mississippi illustrates the same approach from another angle. His attorney says he corrected the testing problem, apologized, and wants to return to his family. But Judge Simpson focuses on the recent bond violation. He apparently went nearly a week without testing, and the judge wants the results from the new test before considering modification. That is significant because bond conditions depend not simply on promises of future compliance, but on whether the defendant has demonstrated that existing conditions can actually be followed. What do you think? Was Judge Simpson appropriately cautious? Or should the defendant's personal circumstances have received more weight? The broader lesson is that successful bond arguments need more than sympathetic facts. They need verified information and proposed conditions that directly answer the court's specific concerns about risk and compliance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.